My name is Benga Odunton. Do you think you can say that?
We can say Benga. Just
You can say Beng. You can say what?
Benga.
That's good enough. There is a silent G for most people, but if you come from my family, the G is pronounced, but you will never hear it. So Benga is good enough. Benga is good enough. And I will be the module convener for this module, and I hope you will enjoy it. Today, we will be doing two things. We'll spend some time. Can someone help the person struggling with the door? Maybe they've run out of social units. Or what is it? China now does to people who are not doing good. Yeah. I'll be teaching the module. I hope you enjoy it. Today we will be doing two things. First, perhaps the first 30 minutes will be spent introducing the module, what the module is about, how it will run, and then in the next 1 hour, 30 minutes, we will be dealing with a substantive lecture. So you are going to be thrown in to the deep end immediately. You have to swim. That's the best way to swim. Get shoved into the water and instinct will take over. At least that's what they do to babies. But you are not babies. You will still survive the full lecture. And it's a substantive and an important lecture at that. So even if after the lecture you leave and you don't like the course, you're in your first week, I think in some universities, maybe here you can still change, you will still have gained something. So keep yourself, get yourself ready for that substantive lecture. But in this first 30 minutes, like I said, I would like to know that you are sure about what the module is all about. And that's what I will deal with. It would be nice to know your names. There are some new faces, a few repeat customers, but we'll do that probably in our seminar hours, next seminar, maybe next week, and so on and so forth. But take it as a fact that in my teaching, you don't have to wait till the end of the class before you ask questions. We are colleagues. We are all members of the same class. If you're a postgraduate student and I'm a lecturer, we are all members of the same intellectual and academic class. So if you have any questions, ask them immediately. If you have any insights that you think will improve the discussion, feel free to talk immediately. So it's an exchange. The module is called International Commercial Dispute Resolution. My office hours are Wednesdays, 4 to 5 p.m. Outside that, it's potluck if you see me in my office. Outside that, there's a possibility of writing emails, but I can assure you emails are not the best way to communicate outside yes or no questions. If you're asking me about should I concentrate on theoretical issues in writing about my topic, or should I go into critical issues? You can't do that by email, because then I will spend the next 45 minutes of my lifetime typing something that you will not understand, and then you will write back, and then I will write back. Those kind of things are best discussed face to face. So make an appointment to see me. But if it's a yes or no thing, you have permission to do this or not, then you can do that by email. Otherwise, try to come to see me. Now we're in class, we talk. I'm on my way going catch me on campus, I'm okay with that. Come to my office hours, I'm also okay with that. But I'm just a warning, not the greatest persons with emails. So try and make it face-to-face. Emails I will respond to as well. It's a second semester course, you know that, of course. And of course, you know, it's 20 credits and so on and so forth. The reading list, let's start with that. Caveats. The current reading list is designed by the last person who taught this course. The last person who taught this course should be here teaching this course now, but he has left the university nearly suddenly. So that's why I'm teaching it. But don't worry at all. I've been teaching this module for the past maybe 20 years of my life, this precise module. So you have lost nothing. I'm teaching it in the previous university before I joined here. But the point I'm trying to make is that that reading list belongs to him. My reading list is what you will find in the Canvas handbook for the module, which is there now, the handbook. You'll find it in the handbook. It contains my reading list and some of his reading list. So what I'm trying to say is, for what you should read, pick what's in the handbook. I will synchronize the handbook with this later. So just pick what you find in the handbook, which I will also come to and explain later. What else do I want to say? Modules, aims and outcomes. Okay. The module is called International Commercial Dispute Resolution. But I must tell you from the beginning as well that we will largely be dealing with international commercial arbitration. Why is it that way? It's that way because international commercial arbitration is the source of the century. What do I mean by that? For this century, for the past 50 years of the last century, international commercial arbitration has been on the ascendancy as the way to resolve commercial disputes. There's litigation, of course, and definitely litigation is one of the international commercial dispute resolutions mechanisms. But the one that I think you will benefit from most, and relying on my academic freedom, would be international commercial arbitration, for the fact that it's the most relevant, and also for the fact that it will benefit you to show that you have done a postgraduate module that concentrates on international commercial arbitration. There are arbitral forums around the world, which if you join at this stage, at an early stage in your career, in your life, you have the opportunity to rise. By the time you are 40, 45, you are one of the few arbitrators in maritime arbitration in your country, few arbitrators in construction arbitration in your country. You are part of the London Court of International Arbitration. You are part of the ICC in Paris. It's a beautiful second career to have in your life, to be an arbitrator. And you don't even have to do it now. It could be something you come back to in retirement. It's always there for people. But I must warn you, the earlier you join the panels, the earlier you join, because it's a bit like joining the Scientologists. The Scientologists, they always have red category. I've not joined them, so I'm just making it up. You have to buy your way up till you get to knowledge. So arbitral groups are like that. You start with membership, then you become associate, or is it the other way around, and then you become fellow, and then you become whatever, golden, diamond, card carrying member, whatever it is they call themselves. You rise. So the earlier you join those, the arbitral agency, the arbitral body you wish to join, the better for you. And that's why I think my choice of topics will heavily rely on arbitration, but it's not solely relying on arbitration. You will find me talking about mediation. You will find me talking about litigation. You will find me talking about conciliation, the entire gamut of what we know as ADR. I won't tell you what ADR means, because if you don't know, I want you to stew in embarrassment until I tell you, which I will sometime down the lecture. So yes, the module is concentrating on arbitration, but it will touch on ADR, it will touch on litigation, it will talk about how dispute resolution is now handled through electronic means, IT, artificial intelligence. It's going to be practical in some sense, because I envisage we are going to have either a guest lecture from a practitioner or a moot arbitration organized with ourselves or amongst ourselves, or both. So there'll be that practical element to it. And there's also going to be that practical involvement, which I will touch on later when we're talking about assessment, where you will be teaching me, you will be teaching yourselves. This is a hands-on module. And believe me, if you are having any doubt in your mind whether this is a course you should do, unless you are made of a different, this is a module you should do. It's actually easy. It is easy to learn about. It is easy to know. It's practical. You will need it in your life. It's about dispute resolution. And how are you going to go through life as somebody with legal knowledge if you don't even understand the basics of resolving disputes? You will come to learn that disputes are normal. Don't freak out when disputes happen. Take it as one of the normal courses of life, which is why learning about how to resolve them and learning about how to resolve them in alternative manners is a golden opportunity. It's not something you should pass on. And yes, you're already sitting here. So I give you kudos for that, for realizing that on your own. Yeah. Indicative outline of the course. What will we be dealing with over the next 11 weeks or so? I've divided that into topics. Today, hopefully, time giving us 21 minutes. Already problems. We will try to cover a critical review of the alternatives to dispute resolution, alternatives to international commercial arbitration and litigation. I'll explain there what I mean. ADR, is it everything that is different from litigation? Or is it everything that is different from both litigation and arbitration? Probably I've never heard of that distinction before, the distinction between ADR and arbitration. Today I'll explain it to you as part of some of the things you will learn under that topic. Next topic will be understanding arbitration clauses, submission agreements, and the applicable laws of arbitration, procedural and substantive laws of arbitration. Massive topic, but it boils down to essentially no one is ever forced to go for arbitration. It's a bit of a, what are you talking about? Every time somebody is taken to court, the court will nearly always say he has to come for arbitration. That is true. But no one is forced to, in the first place, agree to go for arbitration. Once you are not willing to go for arbitration, there's no way anybody can force you there. But once you have agreed to arbitration, different thing entirely. It's now king in your life. Contract is king generally in international commercial law. more importantly, in relation to what an arbitration agreement is. Once you've agreed to go for arbitration, now the questions that we'll be dealing with in that topic or under that topic in that week will be how to draw up an arbitration agreement. How to agree to it. Do you agree to it ahead of time? Do you agree to it when, like I say, when the shit has hit the fan? When something has gone wrong, you can agree to it then. But a wise person will agree to it before. So that distinction, what kind of clauses, how do you draft the clause? You will draft clauses. That's part of what you will do over the next few weeks. You will draft clauses. I assure you of that. So that's what we will deal with in that week. The third topic will be how to actually establish an arbitral tribunal. It's one thing to have agreed to it, to have signed to it, you have an agreement clause. It's another thing to say, okay, we have to kickstart the arbitration panel. How many arbitrators will we have? Where are they going to sit? Is it Bradford Hilton Hotel? Is it, where do we rent? Because arbitration doesn't, unless there are some arbitral bodies that have their own offices and then they use the place. Arbitrations can take place anyway, but where? Is it in Bradford? Is it in London? Is it in Paris? Is it in Abu Dhabi? All those issues. How do we kickstart the arbitration? That's what we will deal with. How do we establish and organize an arbitral tribunal? That's what we deal with in the third topic. Topic 4, we'll look at arbitration in context of oil and gas and energy disputes. Very interesting. Talking about how multinational corporations have been using arbitration, but a particular niche area, which is dear to my past, I would say, my professional practitioner past, is how countries resolve disputes between themselves over their territories, over their joint oil reserves. There's an oil reservoir between 2 countries, between 3 countries, some of it on their land, some of it in their ocean, and they're fighting. Wherever you see oil, there will be a fight soon. The oil cost, part of the oil cost. How do you resolve this? What cases have arisen over the years? Arbitration cases at the International Court of Law. We will mix it all together. What are the unique solutions that tend to be referred to and used by arbitration bodies, by countries, by multinationals? Where do you go when there's a problem between Nigeria and Cameroon? Should they go to the International Court of Justice? Should they have gone to the Permanent Court of Arbitration? Should they have just set up an arbitral body between themselves? What if arbitration fails? What then? Can we still go to a court? Those kind of which direction kind of issues we will deal with. I'm looking forward to that week because I enjoy that topic, because I've been involved in it personally. I found it very useful for sleeping in good hotels around the world. So it's paid me richly and I enjoy talking about it. Powers, duties, and jurisdiction of an arbitral tribunal. What are the powers of an arbitral tribunal? Can it do everything that a court can do? Can you, as an arbitrator, get up from here and go to Saudi Arabia and order that somebody should be picked up and locked up? What can an arbitrator do? What can he not do? What are his duties? What are his duties of impartiality? What are his immunities? What are the challenges to that? Can he end up in jail for his arbitration work? And so on and so forth. We'll be looking at that in topic 5. Public policy. Public policy is an unruly horse. That's exactly what one notable judge said. Not sure if it's Lord Denning. It's not Lord Denning, it's certainly one of the top English jurists. He said exactly, public policy is an unruly horse. So an unruly horse is, most horses have been domesticated. You sit on them and you can tell them, let's go, run fast, come closer. But an unruly horse can just jump and take you anywhere and take you, and you have to marshal it, you have to bring its attention back. What do we mean by that? What it means is that it's difficult to pin down what public policy is. What's the public policy of the UK? What's the public policy of France? What's the public policy of Singapore? What's the public policy of Kenya? They are different because they are different publics, they have different pasts, they have different interests. Now, the reason why we bother about their past and their public policy is because public policy is an exception to the imperative, to the compulsoriness of giving effect to arbitral judgments or arbitral awards, I should say. Arbitration doesn't come out with judgments, they come out with awards. So you go into this expensive arbitration, you get an award at the end, and then when it's time to present it to the country where enforcement is to take place, the country tells you, oh, well, we can't give you this, the benefit of your award because it goes against our public policy. What do you mean it goes against our public? Well, it goes against our public policy that a woman should have even have been an arbitrator. What kind of rubbish is that? The whole world, it's our public policy. We're not going ahead with you, or we're not giving this award an effect because the underlying dispute relates to interests, the charging of interest. And as you very well know, Islamic countries don't charge interest. It's riba under Islamic law, under Sharia law. So how do you navigate a world where every country has a different public policy, and how do you prepare for that as a practitioner in arbitration? That's what we'll be dealing with in that week. And there are different public policies. There's public policy of the country. There could be public policy of the region, regional public policy. There's international public policy. Public policy indeed is an unruly horse, and we have to grapple with it and understand how it can play up under the theory and practice of international commercial arbitration. Then we move to jurisdiction in international commercial litigation. Never forget about litigation. Litigation is also very important. It's always there. It's the orthodox way of resolving disputes. So we need to understand it. If you are going to be a dispute resolution practitioner, you have to know the orthodoxy as well. You have to know what are the jurisdictional rules. How do you take cases to court in different jurisdictions? How does conflict of law operate in litigation? So if a Frenchman buys goods from an Italian and the contract was made in the middle of the Atlantic Ocean and the goods did not arrive in France, but the law when they made the contract was for Singapore law to operate. How do we disentangle all this to establish jurisdiction of a national court? So the conflict of law issues need to be looked at, and we'll be looking at that under topic 7. Then we will look at the drafting of an arbitral award. I hope you can see some progression from how do you sign up to an agreement to go for arbitration to we're now getting to drafting an arbitral award. It's a technical fact. It's also something that belongs to different arbitral bodies. So the ICC will have how it drafts its award. The London Court of International Arbitration will have how it drafts its award. The Lagos Chamber of Commerce or whatever will have how. But there will be commonalities, things that need to be done in writing an award. Should an award be written? Should it be reasoned? Should arbitrators give reasons for their award? How technical or how detailed should their reason be? Should an award be signed? What happens if an arbitrator walks out in an annoyance and doesn't sign the award? All those issues we'll deal with under drafting an arbitral award. Challenge, recognition, and enforcement of arbitration awards. One other thing I can tell you immediately is that even though we're not talking about mediation, a lot of these rules are quite close to each other. So if you've learned it on how arbitration does it, you have a very good idea of how it is done in other ADR mechanisms as well. So notice that there's not one single reference to appeal here. When an award has been given, you don't appeal the award. You can challenge it. The difference is something you will learn later, so I'm not going to spend time on that. You can challenge it, but the grounds under which you can challenge an award are fewer than the grounds under which you can appeal a court's judgment. This is part of the reason why the business community loves arbitration, because there's something final about arbitral awards. Business wants certainty. Business wants to move on. Business does not like we go from the High Court to the Court of Appeal, then we go from the Court of Appeal to the Supreme Court, then somebody looks for a reason to take it to the European Court of Justice, and then after European Court of Justice, maybe we then go to God. Who knows? All that is not good for business. I want to know whether I owe him money, pay it, and then by the next shareholders meeting, we know our dividend is lower this year, we move on. So that certainty is part of what people want. But we also have to recognize that there are reasons why arbitration awards, ADR decisions may need to be challenged. They may need to be challenged because of fear of corruption. We'll have time to look at it, but that's what we'll be looking at under that topic. Recognition and enforcement of foreign judgments. One is award, the other talks about how we do the same thing for judgments. So when a judgment is received from a German court, how do we enforce it in Bolivia, Colombia, and Nigeria, where the company that the judgment has been given against has assets? Why should the Nigerian government listen to what a German court says? And all those kind of issues. Then lastly, as I said, moot arbitration events guest lecture. This is the indicative list of what we will deal with. Please note I said indicative. Don't hold a knife to my throat if anything changes. Say, for instance, the guest lecturer does not come. Don't hold that against me. Say, for instance, my guest lecturer says I can only come in the third week of her. Then we have to shunt things around. You understand what I'm trying to say? So it's indicative. What is your reading? The Bible for this module is Redfern and Hunter. Redfern and Hunter is a classic literature. Is the classic definitive literature on arbitration. Try and grab a copy. They have the practitioner edition, they have the student edition. Get the student edition. What I like about it the most is that it's such a wonderful introduction to arbitration. It's clear, clarity of thoughts, clarity of writing. You can understand what they're saying very easily. So I recommend it very highly. If you have not been buying books in your life, well, I agree this is your generation, but in my generation, we must buy books. We must hold it. You hold it with, with some pride. You carry 4 or 5 books like that. You need to come and see my office. You need to come and see my house. Everywhere is books. I have books from my first degree till today. I keep them. They're physical. I'm a bit like a prepper because when the bombs start flying and the internet, did you hear recently that Russian boats were found around the British coasts, allegedly looking for where the internet cables of the UK is. Yeah, when they snip it, your little Westlaw and Twitter and TikTok gone, gone. But your physical books will be there, and they actually do look good on your shelf. As a graduate, you should have a shelf. You should also have in your office evidence that you read books. So what I'm trying to say is buy at least one of these books, at least one. And as you can see, I'm not saying buy all. I'm saying buy this, or that, and this. Why do I say that? Why do I say and? Because this deal with ADR, and the first 3 deal with ADR and arbitration. This last one deals with litigation. And since we are looking at international dispute resolution generally by the 2 at least, or 2 at most, or 1 at least. Or if you don't buy at all, yes, I'm sure you can find electronic copies via the university's subscriptions. You will be able to find them online, particularly Redfern and Hunter, definitely available on Westlaw. Chapter by chapter, searchable as well. That's the advantage of online. You can decide to just search it for public policy, and it stops everywhere public policy is. That's the advantage of yeah. Outside the core readings, there are recommended texts. Now, you will find that this one, for instance, Dealing in Virtue, 1996. That's quite dated, isn't it? But it's still very good for writing those topics that have to do with the theory. What I mean by that is the theoretical discussions. When you are writing your essays need to be critical. Your essays should not be descriptive. You will find out that Redfern and Hunter is descriptive. It's trying to teach you ground up arbitration. Books like this are teaching you arbitration in context. So your language, your analysis will be fresher, will be critical, and that's what I'm looking for when I'm marking you. That's what you should be doing at the postgraduate stage. I'm just doing this, teaching you arbitration ground up because you did law, you didn't study arbitration, and I think it's good to bring you up to speed. Otherwise, a postgraduate course that deals with topics in that way is not even good for you. At the postgraduate stage, you should be skimming on ideas. You should be dealing critically with, you should be connecting ideas. You should be dealing with specialist areas. You should be dealing with, advanced reasoning. You shouldn't be learning it from the ground up. So what I try to do in my postgraduate courses is to marry the two for you. But certainly take it as your duty not to just be learning about things from the ground up. You have to do both. You have to learn ground up and also learn to pitch with the practitioners who are writing in books like Dealing in Virtue. That's chapters that are wonderful that I think no matter what you're writing on, have a look at it. Probably there's an online version. If not, buy on Amazon. I recommended my book as well on boundary disputes. You don't have to, but it's available online in any case. Then there are wider reading materials, which you should have a look at when you're writing your essays. Look at what some of these books and articles can do for you. there's a lot of material that you can rely on this module. A lot, I assure you. So for instance, I can say you should be able to find all these journals useful. And then there are relevant electronic resources, which are put to you there. You can click on this one in particular. I don't know if we have access to it, but please talk to a subject librarian. I will try to remember to do that myself. It's very useful. It's a searchable index. If you're writing on a topic, you put it on, and all the articles over the last 20 years in that practitioner discussion group will come up. And they are also peer reviewed, so you can cite them for your work. So yeah, quite a lot there for you. I guess you will be thinking, what do I do for assessments? Now, I inherited this module, and it seems I have no choice but to inherit as well the assessment method. The assessment method is 4,000 words essay to be submitted in April before 3 p.m. The devil is listening. It's trying to calculate exactly how it will make you try to submit it at 2:58, and then your computer freezes. So work against him as well. 4,000 words, and it's for 100%. I find it a bit curious as well that there is no continuous assessment, but that is life. You can't have uniformity. So this is what we have in this model: 4,000 words, 100% total marks for the module. But that doesn't mean you're not going to do student presentations. You are actually going to do student presentations as part of our second hour activity, and I'll get to that. So these are your questions, which are subject to confirmation by end of February for the final essays. These are the questions. If there's going to be a change, it will be somebody wants you to remove one comma here, somebody wants you to move things around a bit, introduce the word critical or something in the, so it's largely going to be the same. But by February 24, end of February, we will have a confirmation of the final essay. So they're there for you to start thinking ahead. In addition to this very important 4,000 words essay, is that a question? Yeah, go on.
Oh,
yeah. You're going to pick one. Is that the question?
Yeah.
Just one.
From
the 10. Yeah. Yeah. Yeah, I mean, I do things like that. I give you 10 because I pretend to be nice. I'm not nice. I know you. You're still going to sweat on each one of them, but you pick one of your choice. Just one of your choice. I sort of guess that's what you wanted to ask.
Yeah.
In addition to that, you have the student seminar with topics, which will be these 12 topics. I mean, I'm sure not everybody's in class today, but what these topics will require of you, I can't get it here, is 2 people to work on one of them. 2 people to work on one of them, and then during our next our classes, the seminar classes, the 2 of you will come and give a PowerPoint presentation on these topics. Talk back to the class. We'll ask you questions. We'll throw papers at you. We'll say boo if you don't do well. And we'll clap for you if you do well. We will never do that. It's a peer, thing. But yeah, put some seriousness into it, because these are extra topics which go into detail that I can't afford to do in my lectures. And if you can learn that from each other and also teach me, that's a good thing. So, okay, that's what I would like to say about how the course will run. I'm already 15 minutes above what I wanted to do. Looking forward to that. Questions from the house? Any questions? Okay. If you have questions later, you can ask. But in the absence of you, anyone asking now, then yeah. Disabled. The module handbook. So you can't reach your module handbook. None of you. What does that mean? Disabled.
You have to give access to the students to access.
Let's see if we can do that together. That's well, it says published. So what else do I have to do? Edit. Save. You want to check whether anything has changed? Let me see. I can use that student as well. Oh. Do you want to check whether the learning material, you can see that, the document in the learning material, which is this?
Yeah.
You can see that. Yeah, I can see there's a problem. This course has been disabled. Disabled by who?
It wasn't.
It hasn't changed. Okay, that's a hang up. That's I can't deal with right now. I'll get to the bottom of that. Just confirm again. Has anybody been able to see it? No. I mean, these are all my options, and it shows me published there. So I don't know why it's disabled. Your pages. That's I don't know why it's disabled. We'll get to the bottom of that at some point. I'll ask around. I'll always let's see. Check now. I'll get to the bottom of it. Thanks for letting me know. Okay. But what I could do in the meantime is to put it under learning material. Let's see if I can do that. So that you can, oh yeah, I have to go back to myself. So that you can have access to it immediately. Download. Okay. Serial. Well, I'll do it later, but I'll put it under, I don't know why it's not doing that now. I'll put it under learning materials for you to see while I find out why it's disabled. So edit. So we'll do that later. Okay, let's just do the lecture in the meantime. And the lecture will be on a critical review of alternatives to dispute resolution. We will take the next 5 minutes of introduction. Then we'll go for a 5 minutes break so that you can refresh your brains, and we'll come back for the rest of the lecture. So I'll just introduce it before we go for our break. You deserve that. There are studies to show that people don't concentrate for too long. So it makes sense to take our breaks. Critical review of the alternatives to dispute resolution. As I said earlier on, conflict is normal and natural. Expect conflict, prepare for it by thinking ahead of the least abrasive manner to resolve conflicts. Who can recognize who this person is? Mahatma Gandhi. Did you know that he was a lawyer before? A lot of people don't even know that he was a lawyer. And this is what he said as part of his development, personal development. A large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromise of hundreds of cases. That's his personal philosophy. This was at a time when ADR was not even popular, but because of his nature, because of his advanced thinking, the great man that he is, he said, I became disgusted with the profession, the legal profession. As lawyers, the counsels on both sides were bound to rake up points of law in support of their clients. They were always raking up points of law, bringing case law, making things difficult, trying to win points. The winning party never recovered all the costs. So even when you win through that method, you never get everything in any case. I felt it was my duty to befriend both parties and bring them together. I realized that the true function of a lawyer was to unite parties rather than to just rack up funds and make money. So this is the spirit in which we should understand much of the theory that we will be dealing with throughout the module. That there is no real victory in formal, dispute resolution mechanism if you can achieve a cheaper, faster, less abrasive form of justice that even helps the state, because the state then does not have to spend so much money, so much of its resources in dealing with the hundreds of thousands of cases that we come up with as human beings. So conflict is normal and natural. We don't have to go to court. We can use ADR. And with ADR, we can use our imagination. We can use different methods that people don't even ordinarily consider, as long as we get to the bottom of justice. Justice that is satisfactory to both parties as much as possible. It's never always going to satisfy all parties. Sometimes it's not even in our interest to encourage someone who is doing something wrong, but the important thing is there are other ways to achieve justice other than going to court and going to arbitration. You might be thinking in your head, what's he talking about? Going to court and going to arbitration in one camp and ADR in another? I'll explain. We'll get there. So ADR is any other way, including my favorite way, used for former girlfriends and ex-wives and that kind of. This one, very useful. Try it. It solves, I mean, it's a resolution, isn't it? You resolve it. Or, as you would see, there are so many ways. And even in advanced countries, often until relatively recently, they were still using some of this, what we will call crude alternatives. And I'll show you a few examples. So what is ADR? The most usual explanation is that it's alternative dispute resolution. Others know it as amicable dispute resolution. Others call it appropriate dispute resolution. You can also call it amiable dispute resolution. Whatever way you call it, you realize that it's a realization that courts cannot judge all commercial cases. Don't forget we're dealing with commercial law. But the same philosophy governs the general field of disputes, even outside. So an ADR is not new. It's not something that we're just discovering. As a matter of fact, ADR was how we all dealt with disputes from the beginning of time. What?
Mediation.
Mediation under the palm tree justice. That was how we resolve disputes. Even the legal profession that we are with our wig and gown, these things are relatively recent. Just about 100 years ago, you didn't even have to go to school to be a lawyer in this country. You could just, by sitting in certain coffee shops and working with people in a certain inns of courts, and being part of a class, you just edge yourself in and you're sitting around the courses, you help, and you're in a profession. You get what I'm trying to say? It has not always been this formal. And even now, it's changing, it's moving. So let's not imagine that there's only one way to resolve disputes, and that's through litigation, and that's through the bar association of our country and through the regular courts. There are traditional ways. Some of them are still enviable. You can continue with it. Some of them are thankfully gone. For instance, do you know that it's an alternative way of resolving disputes was to have duels? You know what a duel is? I feel you've done something bad to me. My honor is hurt. Your honor is hurt. We come out to a public place. There will be people watching. I stand like this. You stand behind me. And we agree as gentlemen, because you're gentlemen, of course. We take 5 steps and shoot. Whoever shoots the other, the dispute has been resolved, hasn't it? Has it not been resolved? That was a way people resolve disputes. It's a terrible way, but believe it or not, a vice president of the United States and a former secretary of the USA Treasury resolved their disputes like that. Just as recently as 1804. There are buildings in Bradford that have been there before 1804. So we're talking pretty recent in time. That was when the last fatal duel took place. How about more traditional ways of still doing this in some countries up till now?
Ordered from over 120 exclusive designs and customized your shape.
Now you see where I am
with caution
in the stage of
To
life.
the aggressors. Under the shadows of an uncharacteristically budding ancient tree, however, and we chance at an age-old practice steeped in tradition, where conflicts between members of the Pokot community are solved and aggressors tamed. On this day, a young, aggrieved man seeks the intervention of the village elders, but even before he makes his case, his rival neighbor approaches and is allowed to vent out his anger and frustrations. True Pokot fashion. It is here that peaceful resolutions are arrived at through such violent acts. No holds barred. They go at each other until the elders see it fit to separate them.
Ready?
In a region where traditional conflict resolution structures have outlived the modern day solution sought in the corridors of justice, instant justice is meted out. Each makes his case before a verdict is delivered. It is required of the guilty party to appease the elders. He must pay the crown. His punishment takes shape. He first goes out in search of a goat to sacrifice.
Trigger warning. If you maybe you will feel it. I'm not sure yet, so you may have to cover your. Oh yeah.
Ile matawi mliona nawekwa kwa maji, aliwekwa kwa maji. Huyu alikuwa anatangulia, anaweka maji na kuweka hawa, anasema we roho yako ambaye ni kali, tulia. Yani naweka maji baridi, roho yake iko baridi.
They then offer a sacrifice to the ancestors. Goat feces is used as thanksgiving. As the goat is roasted in its hide. To renew their strength, they drink its blood. This region has seen many conflicts, most of which conventional means of conflict resolution have failed to resolve. Perhaps the reason why they have fallen back on traditional mediation mechanism.
Utaona siku moja hii watu hawezi kupiga kelele na mwingine, hata si hawa vile alikuwa anapiga, yule atapigana na mtu yote na ule ingine atapigana, atakuwa watu ambaye atakuwa ya amani.
From the outside looking in, it is an act that may be frowned at by many given its violent nature, but for the Pokot community, it is an age-old tradition that has instilled such values as unity.
Kama vijana hauwezi kukubali amani ya wasee, hawa watapotea.
Resolving modern day conflict the traditional way. Sally, Citizen TV for courts.
I think they should have saved that goat's life after they beat themselves. They should have just saved that. But point being made, the need to resolve disputes will continue forever. We can't rely on the law courts alone in any country. In this country, you will never be able to resolve all the commercial disputes that people have through law courts. And therefore, we have to start thinking innovatively. And we are already thinking innovatively on how to use alternative means, hopefully not only by flogging ourselves to resolve these disputes. So we'll come back in 5 minutes. I still think I always insist on a break, and we'll talk about the rest of the module. Sorry, the rest of the topic, actually. Can I pause the recording? Possible? If not, we'll just leave it to run.
Yeah. And so this one and fixation. Oh, fixation. Yeah. Tuesday. Oh, last Tuesday, I was really busy at work, so I didn't come. So she late. Oh, today? Yeah. Oh. What's it on? You do Tuesday and Wednesday? No. Oh, Wednesday. Choose the solvency fund. They didn't have it. Oh, yeah. I said to my friend, to do something. So they asked me to do this. Application. Separation. Okay, not perfect. I did the two already. I wish I was. It was. It's on top of that. But I don't think
There's no real. What the rest of it, my songs are about to hit. People that they said this way. It's actually the second time I thought I done one because it's actually yeah, you can't do this. Yeah.
Yes, and you can some people that introduction.
So she should. I do believe that you need to. You did read.
There is one September. There is nothing that actually themselves to. Like they are based.
The only thing they're doing now, they're getting like. I don't believe that's it. Because when I. I say it is funny. Even she wants. Like even very sure you find it. If you have that's what. Just know to have an idea of how
Yeah, you can't. No, you're right. You can't write it. This is very expensive.
just give good data. When I was this time, it's right now.
So when you get a chance to take it.
It's a fun job. I told this. It's not that three. It kind of looks just. Yeah. It's a very way to do it. So it's years. You know, again, it's supposed to be something. What do you add that? Oh, you do. Yeah, it was. It's just this was the school. Yes, you just. I don't really. I have and you just said so you also need these. Yes, really just yes. You think it's okay. And it also bring you back.
Yeah.
You'll read it. It's so one body. Makes sense to me. Yeah.
He's getting just.
And we deviations. And complicated marks. Almost.
Yes.
To put the class in the.
For semester, you, understand that you explain about you, like you was talking about. Yes, 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 I mean, you don't need to be like. It gets really, you don't understand.
You last one,
Everybody's making. You don't want to like this. Yes, like that. It's nice, you know. Experience, you know, like what I say, it's good.
this time you're going through the case, we find a paragraph. Some paragraph.
The seven.
Listen to mine. Okay, so we're back. You get the gist? There's traditional ADR, and then there's modern ADR. Modern ADR delivers for us, as with the case of individuals, also for companies, also for states, also for groups of states. It's the same principles that are at stake. So international commercial dispute resolution is not only for persons, it's also for corporations, it's also for groups of countries, it's also for groups of nations. Nations can have disputes amongst themselves, and these disputes will largely be commercial as they are political. Disputes rarely ever come wrapped up in only one description. They will have several strands, they will involve several bodies of law, but the same underlying principles of choosing to go for alternative dispute resolution mechanisms will work. So, for example, I've given you in this slide how ADR can become the only solution. There is this situation where the UK and the EU have been at loggerheads for a number of years. The UK wanted to leave the EU. One of the reasons why the UK wanted to leave the EU was precisely because EU courts were being frowned upon by nationalist figures in this country. So there are people who hate the idea that Britain is subservient in another court, not a UK court. And they would rather just leave the arrangement that makes that possible. So what do you then do when we are having that disengagement? And that disengagement still has to be handled through legal means. But you realize that it's going to lead to disputes. So courts now is the very one place you can't go to. That shows you that sometimes courts are so not the solution that it's impossible to even use them when the need arises. So that's why they've said here in the EU-UK Trade and Cooperation Agreement that when disagreements between the parties come, either party may submit this to an independent arbitration panel. They even expressly said that this must not include going to court, particularly the European Court of Justice. So disputes are normal. They will occur. Over the EU, they will occur over the exit disputes, how we are living. They will occur over trade disputes. They will occur over which dispute resolution mechanism should we use. For me, one of the most interesting parts of international disputes. And you will find it because the very first book I've ever written was on the International Court of Justice. So I had to read the cases that were submitted to the International Court of Justice up to that year. I started from 1945 to 1999 when the book came out. Now, one of the things that became clear to me was that there are phases in disputes at the International Court of Justice. The first phase, it's nearly always there, is the phase where one state will deny that the court has jurisdiction. And guess what one of the grounds usually is? They would say there is no dispute. So we will have a dispute whether there is a dispute or not. Isn't that interesting? Somebody would deny that there's no, actually, I have no dispute with him. Why is he bringing me to court?
Yeah.
That's a dispute over whether there's a dispute.
Yeah.
So the fact is just the fact that disputes are normal, and you have to be flexible in the mechanisms that you make available in the first place. So have an availability, an array of possible means, and then make sure that they are ready, that there's knowledge about them, that they are quality in their own way. People can get good justice there. And that's just how it works. So resolving climate change related disputes, again, can be done through arbitration and ADR. This is an upcoming area of dispute resolution. The ICC Commission talks here about the use of mediation, expert opinions, dispute resolution boards. There are independent dispute resolution bodies, private. They are not owned by government. And that itself is one of the beauty of this area of law and practice, that private practitioners can nobody forces you to go to any particular, it's not written anywhere that you must only use dispute resolution bodies that are set up by governments. No, you can use the ICDR. You can use private conciliation bodies, private mediation bodies. One of the more international, well-respected, reputable ones is the Center for Effective Dispute Resolution, ICDR. The ICDR has its own mediation clause. What that means is that when you want to use that panel, you have to submit yourself to the use of that panel that is expressed in a mediation clause. A mediation clause, like an arbitration clause, is a very important stage in the life of dispute resolution. People are not forced to go to ADR. People are forced to go to court. If you receive a court summons and you don't go, good luck to you. The case will proceed. The court will listen to only one side, the side that brought the case. That doesn't mean the court is going to find for the person, because courts will still consider the law, but it's very likely that the person will get, because it's uncontested, and therefore it's better to show up. But with ADR, you're not forced to go. You can receive an invitation to come for ADR and refuse to go if you have not agreed to go for ADR before. I hope you get this shift I'm talking about. First, you have to say, I accept in relation to this commercial relations that we're having, that if there is a dispute, I will go for ADR. At that moment, you are bound. If you don't have that clause, if you've not signed up to that possibility, if you've not tied yourself, for instance, to accepting the ICDR as then you are not bound to come. But if you have signed up to it using one of these highly developed clauses, which will tie you down to the mediation will take place in the city of London, in the UK, or the language of the mediation is going to be French. You can see quite a number of important details have been put there. That is what we call a mediation clause, and that ties you to go to show up for mediation. That doesn't mean the mediation will succeed. That's a different thing. But you should come there because you've signed up to mediation. And particularly, God bless you if it is arbitration. I'm not looking down on mediation, but I can tell you that arbitration is something you cannot get away with running away from if you have an arbitration clause. The arbitration clauses, that's another topic, but arbitration is such an alive topic that every topic is connected. So I can't teach you arbitration clauses without telling you about the effect it will have on your at the implementation stage, at the enforcement stage. Everything is connected. So I'm telling you now that if you've signed up to an arbitration clause or a mediation clause, it's going to affect your obligation to show up. But if it is particularly an arbitration clause, not even the nuclear incident will kill your obligation to show up for arbitration. People do it every day. Lawyers will run to court because they prefer at that stage to have litigation. But surely and certainly, courts, the other side particularly, will just have to come to court and flash the arbitration agreement. This of 2030, sir, my lord, the respondent has an arbitration clause with us to submit the dispute to the ICC in Paris. And the court will say at that point, you have to go to Paris. To arbitration, you must go. That's how powerful this clause is. So you have to be very aware when you are in practice, when you are designing dispute resolution mechanisms, you have to be quite deliberate in understanding that it may look mushy at this stage. It's usually done towards the end of the contract. That they will, oh, how are we going to resolve this? Oh, let's do it in Paris quickly. Yeah. You sitting in this class, having graduated from a course like this, should be aware of the seriousness of what you are doing at that point in time. It's not a joke because it will become, it's a contract. And as I said, if it's an arbitration contract, even if a nuclear incident has happened and there are only 5 people left on Earth, but out of those 5 people, you have the, the disputants and the 3 arbitrators, that arbitration must hold. Even if all they can do is to come and say, yes, we've sat, you know what, there's nobody to even be a registrar. Even if we give you a judgment or an award, nobody to enforce it. That's a different thing. But you must come for the arbitration. That's how strong it is. And we'll talk about that later. So we're at this stage, we're talking about ADR. How important is ADR? It's so important now that the civil procedure rules of this country, England and Wales, the jurisdiction, says that what? And I'm quoting exactly from the civil procedure rules. Who is a practicing lawyer among you? Good. Okay. Let's go with him here. What's the importance of the rules of court?
There is a difference between procedure law and substantive law.
Very
Procedure
correct.
gives you the procedure, that is how the law is enforced or the process of court has been enforced.
Fantastic. But how important is the procedure to
Without
taking your...
you can't go for private.
Thank you very much. As serious as that, as he has described, what does the civil procedure rules of England says? Litigation should be what? A last resort. That shows you how important what we are doing here is. So if litigation should be a last resort, then a lot of lawyers should be learning about ADR. A lot of lawyers should be learning about arbitration because that's a second profession to be had. And that's an important thing to know about what's going on there. Yeah. So parties should continue to consider, even after you've gone to court, parties should continue to consider the possibility of reaching a settlement at all times, including after proceedings have started. Sometimes even including up to the morning of judgment. Might be better for you on the morning of judgment before the judge reaches to say, my lord, the parties want to settle. Could you give us some time to settle? Because you never know what the judge is going to say later. It may not even be in your common interest. It's always better to reach settlement if possible. What is ADR? Third party facilitating a resolution. There's always most usually a third party. The third party may be the one deciding the dispute. The third party may be the one facilitating. There's a difference. Facilitating the dispute. So in mediation, somebody sits in the middle, mediating between the parties, but he is only facilitating. It's bringing them together. He's a mediator, amiably mediating between them. He facilitates. The decision that will come at the end of the mediation has to be jointly agreed to by the parties. But in arbitration, it's still a third party, but the third party is deciding the dispute. He makes the decisions, or the parties, or the arbitrators as a panel make the decision. In neutral evaluation, it gives an informed opinion upon which the parties are then advised as to the correct position to take. So different ADR mechanisms do different things, all towards resolving the disputes. And of course, then you have ombudsman scheme. What's the ombudsman? Anybody going to help? Another practicing lawyer, the lady? Yeah. No, the lady in the back. Huh? What's your name? Benedicta, do you know what an ombudsman does? Yes, he is a go-in-between man, but he has a particular unique office that he holds. Who else knows what an ombudsman is?
It has a quasi-judicial authority in order to resolve disputes among the parties, and it has a finality to that.
In a particular trade, in a particular area. So there's an ombudsman for employment in people who are employed in communication industry, or there's an ombudsman for people, different areas. But an ombudsman is usually paid for by the states. And that's so.
It's a procedure before we go to the court. We have to exhaust this ombudsman thing, and then if the dispute arises or the aggrieved party feels, and then it can go to the court as well. In order to challenge that, whatever he said.
Yeah.
If there is any misled or any factuality misled, or the national justice principles are not being followed.
Yeah. So the ombudsman carries out investigations. Yeah. Can listen to both sides, can call them for evidence, and then take a decision or advise the parties as to what to do. So that's it. You were saying, making a point, right, Benedicta? Yeah. Okay.
And the ombudsman, like said, it has to be the particular let's say sector, like just like the medical,
exactly.
this the health. I think theirs is I can't remember the committee.
Yeah.
It has to be.
And it depends on this country. Different countries have different ombudsmen.
And it's not like he has to do an investigation. So just like the agreements where you have to pick
the clause.
The clause,
Yeah.
who is going to be that particular person.
Yeah.
So the institution of that department picks, and not the clients, not the disputing party.
It's the person who is seeking, who is dissatisfied, who announces that there's a dispute. As a person who seeks the ombudsman based on the sector under which the dispute exists. So if you're having a problem with your telephone provider, there's an ombudsman for those.
That is state basically.
Yes.
Makes that basically procedure.
Yeah. So again, I think the lesson for us to learn as lawyers and as people who will be advising companies and parties later is you listen to the dispute and you say, okay, is there an ombudsman in that area? If there's an ombudsman, as he rightly said, you might have a duty of exhausting your local remedies before you take the case further to any other court. unless, of course, you have a clause that says it's going for mediation, in which case you have to go to mediation at that stage. But if you don't have a clause that forces you to go to mediation and it's something to do with the medical negligence, like you said, you have a duty to go to the ombudsman as exhaustion of local remedies. When the shit hits the fan, please don't report me. I love that phrase because everybody gets it when I say that. When the shit hits the fan, everybody wants to run to the highest authority. If possible, you want to go to the International Court of Justice. You know how many applications the International Court of Justice receives every year around the world for people individuals that want to bring cases to them. At least at the last time I checked, around the time I was writing the book, about 300 applications are coming from individuals who feel so pained about a dispute that they want to bring it to the International Court of Justice. The only problem with that is that the International Court of Justice does what? Handles cases only for states. States, there are individuals who want to go there. These are individuals who want to jump the ombudsman, they want to jump ADR, they want to jump their own national courts, they just want to go to the highest. So there's that there's that instinct to always try to escalate. But in law, we have the principle of exhaustion of local remedies. Yeah, make your point.
Before go to International Court of Justice, we have to exhaust the highest forum of the national court and then be eligible for that.
Yes. Again, it depends. This is exactly what I mean by the first phase of proceedings at the international courts. Most international courts is the jurisdictional phase. So one party may be raising that, but they have not exhausted the remedy. We could have taken this to the West African Court of Appeal or something like that. Why are you bringing it to the International Court of Justice? That's part of what you may raise, but it doesn't mean it will succeed. But it may succeed. That's why you go through that phase. And the other party will say, well, I can't take it to our national courts because I don't expect justice there, given that the state is the owner of that body that I am having this dispute with. And then it won't.
Still, you have to exhaust this one.
Sometimes. Yeah. This is what the court will decide. But as a principle, exhaustion of local remedies is advised. Yeah.
Before you go to the court, you have to like present a certificate that you have advised your parties to exhaust all avenues before.
Yes.
We have the action counseling certificates.
This is exactly what you do as a result of the civil procedure rules. And the civil procedure rules provisions of this country that I've shown you exist in many common law jurisdictions like that. So I expect to find it in Nigerian law. I expect you to find it in India. I expect you to find it in Jamaica, Australia, the common law countries. For the civil law countries, I can't say for sure, but my life experience of studying law shows that the instinct of justice is the same across all cultures. You will find out that they have their equivalents of that as well. And as I said, ADR is the source of this century. That's what across the world seems to be the future of dispute resolution. I think I don't have to waste your time teaching you definitions of ADR. Yes, please go on.
Just to get the clarity on the ombudsman scheme.
Yes.
It cannot be between two individuals. It has to be between an individual and like an organization.
Yes, most likely. Again, it's difficult to speak for all countries. Some countries have an ombudsman for human rights instead of a National Human Rights Commission. So if they have that and you are a house help who has a dispute against your employer who has been whipping you or not letting you sleep well or whatever it is, you may still need to take it to an ombudsman, even though it's between persons. So everything international is necessarily also comparative. But as a general rule, what you're saying is in fact, ombudsman mechanisms tend to stand between individuals and institutions. Sometimes they also handle between companies. Ombudsman may handle disputes between the, informer and his agency that sends him to work in place because that's the nearest body that deals with their industry. But I guess we have already made progress if we begin to understand that there are multiple mechanisms that you may need to keep your eyes open for in dispute resolution, rather than always thinking that the next port of call is the high court closest to you. And it's something that has developed over time in different countries in different ways. I told you about the civil procedural rules. The civil procedural rules are more recent, but a lot of that development started in England from the case of Calder Bank and Calder Bank, where the English judiciary in that court made it clear that there is an expectation that litigants should be seen to have considered ADR in their resolution of disputes before they come to court. So you can see how that kind of judicially approved philosophy soon made its way into the wolf, what is known as the wolf, the wolf, it's not study, yes, there's a name for it. The wolf, WOOLF. It was all done under the government of Tony Blair, forgotten the full name, who then came up with the section 1.1 or rule 1.1 of the civil procedural rules that I've been talking about since, which says it should be an exception that you take cases to court and all that. So there's a rich history of the philosophy towards giving ADR a new relevance in international commercial relations and within nation states. Now that's the good news. The awkward news is that for some of us who are purists of definitions, who are purists of understanding, who are purists of law, maybe because we are lawyers, that's all. When all the tool you have is a hammer, all problems will start looking like a nail. So our training as lawyers encourages us to look for precision. Precision is so. I spent 3 years of my life earning my doctorate on one question in space law, and the question is about precision. When you say outer space belongs to nobody, belongs to all countries, belongs to mankind, and you also say in the Chicago Convention that every state has complete and exclusive jurisdiction over its airspace. Lovely, I clap for you. That's what international law does for us. It settles big picture things like that. But how does that help me? Where is the complete sovereignty of states in their airspace ending? And where is this massive, everybody owns outer space, where does it begin? I found that there's none, different theories, so that became my PhD question. That's our training. Now, how does that apply to what we're discussing? Definitions of ADR remains confusing. And that's a big problem for those of us who are purists. It may make sense to only people who are lawyers. I've been to a National Bar Association meetings where everybody just talks about arbitration as ADR. And I'm holding my head like, where did you get that from? But the whole National Bar of a country agrees that arbitration is ADR. I don't agree that arbitration is ADR. That is a problem in ADR that exists today. There is a definitional quandary. You know, when they say something is a quandary, it's a quagmire. We are stuck in the mud. We don't know what we are talking about. And I can prove that to you. There's this gentleman known as Mani Ruzaman, very well respected professor for about 10, 15 years ago now. He left the University of Kent, which I was, so he's more or less one of my, what I would call my mentors, signed all my promotion references. You have to look for people, wonderful scholar. He said in an article dating back to 1995, throughout this article that I'm writing, conciliation and mediation will be used interchangeably. The terms mediation and conciliation are often used interchangeably by the majority of scholars. How does that help me as a purist of law? You are telling me that a snake means a monkey, and I should just accept it. And the entire country is just run on that basis. It's one of those things that when you say an elephant in the room, it's like as we are here, there's a big elephant there, and all of you just sit like this, you're not looking at it. And are you people okay? Can't you see this elephant? To me, this is a big problem. The next article says, or the next person I quoted, the term mediator seems to be frequently used in American usage, while that of conciliator is used in British English. Another person says, in my opinion, conciliation is used interchangeably with the term mediation. This is mind-boggling. Okay, I have a client who has just bought a concession in Guinea for 100 hectares to prospect for gold. And I have to advise him on the dispute resolution clause as his lawyer. And I want to use ADR as one of the, instead of saying we're going to court or we are going to the African Court of Justice or whatever, I want ADR. Am I supposed to tell somebody who is entrusting me with that, is going to pay me £50,000 in legal fees by telling him that, yeah, use conciliation, but conciliation may meet mediation? It's difficult for me to do that. It's difficult for me to do that. But that's what we are doing. It's mind-boggling. Here is the ADR quandary again proven. The International Chamber of Commerce says, internationally, the terms conciliation and mediation are used. It's the same thing they are repeating. So which one is it? At the same time as they are doing this, do you know what these funny people are doing until recently? They have conciliation rules. Then they have mediation rules. And then they are telling us that they're interchangeable. Big problem from where I sit. But let's agree, there are lots of benefits to receive from ADR. I'm coming back to the definitional quandary. It's still good. Yes. Yes, there is. There is. I sorted that out, at least in international law, when? Way back 1999. When I still had only a master's. When I published my book, I still had only one master's. I didn't have a PhD. I never knew I would do a PhD. But in that book, and I'm quoting myself here, there's a difference. Here is my definition for mediation, and here's my definition for conciliation. And in mediation, an independent third party assists the parties through individual meetings, and then finally joint meetings, to focus on the strengths and weaknesses of their cases so that they jointly arrive at a decision. But the conciliator listens and ascertains the facts of the disputes, tries to bring the parties together, and may make recommendation or give an assessment. So he can give an assessment. That's a substantive difference. That's different. This one may try to bring them together. What if they never come together? But in this case, he can give. He has the right to give. This man has no right to do jack. His only right is to try and continue bringing them together. This one can come to a conclusion. And you know what? Even though I say here that the recommendations are merely advisory, I'm talking about in international law. In national conciliation, it can be binding. It all depends on what you put in your mediation clause. It depends on what you put, in your conciliation clause. And I will advise you not to go for any conciliation clause that does not talk about finality of the process. Otherwise, don't bother. The bank's just going to use it to delay you. And yeah, so I think there's a difference. And I think it's really unique that we live in a world where these things have been conflated. But the new thing that's been going on in the last 3-4 years, I've noticed, is that countries have finally started just dropping off conciliation as if it doesn't exist at all. So they don't even talk about it again. It's like a cousin that has just left and disappeared from everybody's mouth because he has been stoned to death in the markets somewhere, and everybody's ashamed of him. I'm just giving you an example. Nobody talks about countries just now come up with a mediation act or a mediation act. They just ignore consideration. It doesn't help me. I would want us to wrestle with the forensic definitions and keep these categories alive. Yes, please go on.
It's still like ICM that's focused on just conciliation, and then there's arbitration that focus arbitration, the Institute of Chartered Arbitrators that focus on just arbitration. And like you said, I also disagree with those other authors of that said conciliation and arbitration are conciliation, the end game of conciliation settles at settlement, and arbitration settles at award. So they're totally different.
Okay, I'm happy to have purists like myself on the class. Yeah, I think this category is sure. And if we say they are the same, okay, let's agree. All of us agree together that they are the same. Not that in Nigeria it's like this and then. But again, that's the thing with international commercial issues. You will never have complete uniformity, whereas uniformity is the aim. We're always trying to, that's why we have model laws, the model law for arbitration. The model law for arbitration done by UNCITRAL, the idea is to make sure that by the time each country is writing its own mediation or arbitration rules, they give reference to the model law. And that way, everybody tends to coalesce towards the same practice. Yeah, it's a good thing and it could be a bad thing. Well, let's not over-focus on mediation and conciliation. There are other arbitral, ADR mechanisms. Have you heard of the mini trial? The mini trial came out of this case in the US. It's a very unique system where if a company or two companies, say Microsoft is having a problem with Unisys or any of these other big, software companies, instead of taking it to a normal court, instead of even taking it to arbitration, between the companies can have a mini trial. They just get an external facilitator who stays with them, and that way the software codes don't have to be shared with anybody. In fact, that there's a dispute doesn't have to be known by anybody. You just sit there and you bring your, as long as it's not the people who directly wrote threatening letters to each other as executives that are directly involved, they will not be involved in the mini trial. But okay, we have a dispute. Yeah, so what's going on? How do we solve it? Let's listen to what the the facilitator says. And you have a trial. If you like, you can even start talking about case law. With time, the independent person in between will tell you, this is probably where the judgment will go in the court. And the party that is losing in the mini trial will know what will most probably happen in court. And you resolve the case. In a sense, it's very close to the whipping of each other that we saw. If it includes you have to buy us drink at the next golf tournament. Yeah, that's it. Whatever it is, dispute is resolved. Expert determination. Expert determination is another ADR mechanism, and it is used sometimes as a final determinative process, sometimes as assisting towards a final determinative process. And I'll give you an example of where I've seen expert determination used. Now, the Nigeria and Cameroon took themselves to the International Court of Justice for about 9 years to be precise, between 1993 and 2003. Yeah, just shy of 10 years. And they came out with a decision. The decision was that one country had to lose a peninsula, and also both countries had to lose across their 2,000 joint boundary between them, 2,000 kilometers joint boundary. So the judgment was Now the court has done its job. You go and implement the judgment. Guess what? The judgment was given in 2003. I personally stayed with them for 10 years, between 2003 and 2013. I was closely involved with the implementation of the judgment. Believe me or not, that judgment implementation is going on as we speak. 2003 judgment, implementation going on till now. But why am I saying this? Part of what we hit in the implementation process while I was with them was when we get to rivers that are supposed to be boundaries. One country will say, this is not a river, this is not a river, this is a brook. This is a stream. The reason why I'm saying this is because it prefers the boundary to move. It will be suggesting another body of water there. And every surveyor, every geological expert in the team will be saying, who will call this a stream? Do you know, over this issue, we had to say we need an expert to come and decide for us on some of this, whether is this a river, is this a stream, is this the bifurcation, is this not, is it bifurcated out there? And they appointed the former Surveyor General of New Zealand to become an expert. And his job was to tell us the difference between rivers and stream. Yeah. So in that case, expert determination was used to facilitate within. Sometimes it can be used to facilitate within. Sometimes it can be that his judgment is what is all you are looking for. ADR in its best, Okay, it's my first lecture. I can't finish it as I knew it wouldn't happen, but I think it's been useful so far. We've introduced ourselves to the module. We've done at least half of my 57. So next week, we will do the rest of this lecture, but you will also receive seminar questions. You will receive seminar questions relating to this lecture that you will get in your announcement. And that way you will have something to prepare for our seminars next week. Short break. When I say short break, it has a technical meaning between us. I never say bye-bye.
For what?